Well, our legal counsel is in today, Richard Samaniego, in for Charlie O'Hara, 436-1212, the number to call. Thanks for coming in to us
You're
today.
welcome.
Appreciate it. Good to have you here. All right, we do have a couple callers on the line for you today. Go ahead, caller. What's your question for Richard?
I want to know if this is forgery. In big black letters it says acknowledgement of receipt. I, John Doe, hereby acknowledge receipt of the attached notice of ordinance violation. Can somebody else sign John Doe?
It sounds like you received notice or service of process of some sort. Are you saying the person that signed it is it forgery if the person that signed it?
Yes. Somebody else signed my name.
Okay.
John Doe. Somebody else signed John Doe. Is that legal?
No. Usually in those types of situations, when you're acknowledging receipt, it's a type of or perjury, or it'd be a different statute than forgery, unless they're trying to pass it off as a legal document or deceive the person. Those would be all the factors that would go into forgery. But if it's just a false identity or just a person putting a false name on there for some other unlawful purpose, it'd be a separate section of the statutes for that.
So if that were to happen to you, then, I mean, how do you go about proving that you didn't sign it? Or can you even do that?
You can. It really depends on what the use of the document is for.
Okay.
If it's for legal process, there's a lot of things that person can be in trouble for, obstructing legal process, all kinds of different things. So it's really factually dependent on what the purpose of that acknowledgement of receipt was for.
Okay.
You know, if there's a million things it can be for: receiving a package, receiving service of process. It's a very factual dependent situation that we would need more details on, but it certainly could be forgery, but it could be also a plethora of other things.
Okay, thank you. Appreciate that, Richard. All right, we do have another caller on the line for Richard this morning. Go ahead, caller, what's your question?
Yes. If I have judgments against me, would I be able to include that in a Chapter 7 bankruptcy?
It depends on what the judgments are. I practice family law, so there's judgments out there for spousal obligations that cannot be discharged in bankruptcy. So it really is dependent on what those judgments are.
It would be a credit card judgment against me.
Okay. And all those are subject to the jurisdiction of the bankruptcy court, and certainly could be included. It's just dependent on the bankruptcy court on that.
So that can vary from one court to another.
It sure
then?
can.
Okay.
The type of bankruptcy she's claiming, and also the type of debt factors in.
There always seems to be a lot of leeway there.
There's everything in the law is very factually dependent, so that's why we always say go seek an attorney to get those facts clarified. So.
Okay. Okay. We do have another caller on the line for Richard this morning. Go ahead, caller. What's your question?
In a divorce case, can you file? I don't know how you say it, but can you get benefits from the spouse's future inheritance?
Again, it really depends on the factual situation. In Kansas, once a petition for divorce is filed, everything between the marital parties is considered by the court in a fair and equitable distribution. There is some presumptions that property acquired prior to marriage is not included in the marital estate. However, like I said, everything is brought into the pot as marital property once the divorce is filed, and can be considered, if it's to equalize the estates of the parties, or to be considered a final and fair distribution of the marital property.
Okay, thank you, Richard. We appreciate you coming on the show, filling in for Charlie. You were great. Thank you so much.
Thank you very much. Nice to be here.